do, but I think that here...
a result here, you'd admit, would logically entail permitting California's law or ones like it to pass as well.
No, you don't have to go that far.
Oh, I know I don't have to go that far, but you just said you would go that far.
I personally would, but I don't think you do, Justice Gorsuch. And the reason...
No, I appreciate your candor about the extent of where your argument leads. And so it seems to me that, you could have a state law that doesn't just flip the presumption and require express oral consent, but requires express written consent, maybe a sign, maybe an irrebuttable presumption, flipping of and I appreciate your candor on that. The other question I want to ask you is the black codes. I struggle to see what relevance laws that are outliers, and in Bruin we're not supposed to consider outliers, that they're put aside under our test. We're looking for the mainstream and a significant tradition. And you rely very heavily on an 1865 black code law in Louisiana. You say it's a dead ringer and a reason alone to affirm the judgment. And I really want to understand how that could be.
So let me take those in turn. So first, with respect to the California law, I think it's really important to understand here the Hawaii law has a much broader definition of consent.
I know it does. That wasn't the question. Why don't you answer the question posed?
About the California law?
No, I want to understand how you think black codes should inform this court's decision-making. It's quite an astonishing claim to me.
So the black codes are undoubtedly a shameful part of our history, but that doesn't at all mean that this particular law is irrelevant to Second Amendment analysis for two reasons. First, the Solicitor General says correctly, as she did just now, that Louisiana wasn't a state in 1865. The relevant point is what happened in 1868 when Louisiana was admitted to be a state. The Act of June 22nd, 1868, admitted Louisiana as a state. That was the Radical Reconstruction Congress. It examined the Louisiana laws, including this specific statute, and Louisiana was admitted into the Union by the Reconstruction Congress. There were many laws that the Louisiana...
You're not answering the question. The question is, it's an outlier. And you just call it a shameful outlier. And I agree with that. And Bruin was supposed to look at the mainstream of our tradition and history, not outlying statutes that were unconstitutional the moment they were passed, and yes, when Louisiana was admitted to the Union.
So Justice Gorsuch, when I said it
I understand a lot of people like to cite the black codes who promote gun restrictions, who would otherwise, they would be garlic in front of a vampire in front of them. But here they like them, they embrace them, and I'm really interested in why.
So Justice Gorsuch, when I said the black codes were a shameful period, there are parts of the black codes like this particular statute which were race neutral, which the Congress of the United States, the same Congress that ratified the 14th Amendment, implicitly blessed by admitting Louisiana back in. It didn't treat that with respect to other laws from other states, but it did here. And most importantly, even the opponents of the black codes recognized, as the Sickles General Order says, that you have no right to carry a firearm onto someone's property absent their consent.